Good afternoon. This is Lillian Morvay, the founder and CEO of the Independent Broker-Dealer Consortium. I'm really happy to provide you today with an outstanding panel of IBDC Alliance members. The Alliance members work collaboratively together on litigation issues. We provide expert services, legal, compliance, regulatory, cybersecurity, and insurance. And I'd like to introduce you to my panelists as we discuss today the SEC and FINRA 2021 exam priorities. And this is really a blueprint for the claimants attorneys. I'd like to introduce, we've got a couple of attorneys from the law firm of Kaufman, Dolovich, and Volek. Jim Young, who is in the Chicago office, as is his partner, Dan Hetzel, also in Chicago. We have two distinguished attorneys from the firm of Kessler Collins down in Dallas, Texas. We've got Gary Kessler, and we've got Brian Roman, and we've got Chad Weaver with Freeman Mathis and Gary. Chad is in the California office. So we're going to start our conversation today just talking about the significance of these 2021 SEC and FINRA priorities and how they should impact the way broker-dealers and RIAs conduct business and make an assessment of their own compliance and supervisory and protocols, internal protocols, how they do business. Chad, can you start our conversation, please?
Sure. Good afternoon, everyone. So I think, more and more we see these priority letters being issued by our regulators, the SEC and FINRA, at the beginning of every year. And we're seeing them becoming much more detailed in context, providing citations to past regulatory notices to members and so forth, and really giving guidance, for once, to the industry of what I think are their expectations. Is it a roadmap for the plaintiff's bar? Certainly, it highlights issues that many of them may not be aware of. So to a certain extent, possibly. I would, like I said, they're in such detail. I'm looking at the FINRA priority letter, and it's 45 pages of very specific subjects. They identify exam findings. They identify effective practices, which we as attorneys would, seem as maybe best practices, and certainly guidance to follow. So if I were any firm, if I were part of a firm or compliance team, I would certainly be wary of these. I would go through these, subject by subject. If something pertains to your business and your business model, I would want to have, responses and some idea of, what you as a firm are doing specific to each of these items.
So
I'm not sure that it is a roadmap as for litigation as much as it is a roadmap for examinations by FINRA and the SEC. I think that what we've done on the compliance and regulatory side is we've advised our clients to look at these letters, look at their WSPs to make sure that their WSPs address some of the major issues in these letters, and go over some of the shortfalls that their WSPs may have with respect to the subject matter, because the SEC and FINRA is going to come a knocking on the door. And when they do, they're going to have these priorities in their mind. So you better be able to address them.
And one of the things that I thought was very important in the SEC's priority list was the statement that more than 130 enforcement actions from 2020 exams have been initiated as a result of exam findings. And they then stated that they reasonably expected that there would be more enforcement referrals that would come from these 2020 exams. So absolutely, to know what the SEC is looking for with regard to Reg BI or other issues, know what FINRA is looking for, absolutely could avoid being one of those enforcement referrals.
There's been a lot of talk and certainly a lot of presentations that have been addressing the Reg BI issue. Last year was all about getting ready for it, making sure that your CRS was properly filed and that you were in compliance. Now, it's my understanding that the SEC has really given a bit of a grace period for broker-dealers and RIAs to be in compliance, but they also warn grace period is up. So let's talk a little bit about Reg BI, what you anticipate is going to come out of examinations, what are they going to be looking for, and what do broker-dealers need to do? Jim, why don't we start with you?
One of the things that Reg BI does is I think it disguises some of the things that we see the SEC focusing on. The biggest thing that I've seen the SEC focus on these days is the revenue sharing aspect. During Form ADB season, we advise all our clients to update their Form ADB to talk about revenue sharing. And I think you're going to see a lot of cases come out of revenue sharing. In Reg BI, it's disguised as, full disclosure of conflicts of interest and the like. But there's definitely a intense look at that. I've gotten 3 different SEC offices looking at that. The SEC in LA, in Chicago, and in Kansas City are all looking at that issue right now.
Yeah, I think specific to Reg BI, just going back to the priorities letter, the FINRA certainly, was front and center of their section on communication and sales. And I noted that there were 16 or so related considerations. If you go through each of these questions, they're pretty specific as to, are you doing this and are you doing that, specific to Reg BI. So here we see yet more guidance from FINRA, in this situation, asking very specific questions regarding training, regarding documentation, WSPs, and so forth, specific to Reg BI and your compliance with Reg BI, as well as the Form CRS.
And the SEC exam team had identified and notified hundreds of firms that they failed to timely file the Form CRS. So that certainly is of great concern. The SEC identified that it received over 13,000 Form CRS, but there are over 13,900 advisory firms. So it seems as if there are a number of firms that are not in compliance, and they don't have a whole lot of time to become compliant with respect to Reg BI. Are there any other comments that you'd like to make with respect to Reg BI and preparing for this exam that clearly the broker dealers and RIAs are going to have to face?
Yeah, hi Lillian, I would recommend that the firms take a look, if they haven't already, at the April 2020 risk alerts that were issued by the SEC with regard to Reg BI compliance. And they really give, in Form CRS as well, they really give a roadmap as to what the examiners are going to be looking for when they come in and look at whether or not your WSPs are up to date, whether they're dealing with the issues that the SEC or FINRA, for that matter, believe need to be addressed to satisfy those 4 duties that make up basically Reg BI. In literally, they go into enough detail, they'll tell you exactly what documents they expect you to have so they can review them. So if you don't have them, you're just really asking for trouble. So I would definitely pull those back out. And the SEC just reaffirmed that those risk alerts in this priority letter. So clearly it's still on their mind, and they want firms to know what they are expecting as far as documentation.
Wonderful.
And I want to also, if I have a second, to comment on what Jim has said with the revenue sharing. This really is we were talking about this just before this went live. Jim's comment about this being regulation by litigation is absolutely true. We finished up a share class matter with the SEC San Francisco office with no notice. In fact, it is the first case where they included 12b1 fees from money market funds, okay? Not just mutual funds, but revenue share from money market funds were included in the investigation. They were never part of the self-reporting initiative, and it basically just came out of the blue. And I think you're going to see the firms that self-reported on the share class are now going to come back for round 2 on their money market revenue sharing, and probably any other sources of funds that were received and not disclosed in the ADV.
They're also looking at expenses on one of my exams. They're looking at expenses associated with some of the share classes that you pick. If there was a cheaper, less expensive, and this is
Unfortunately.
quite a bit.
All right. Well, another topic that comes up with some frequency right after Reg BI this year is elderly and compromised investors. It's never a surprise when we see that as one of the top priorities under both the SEC and the FINRA priority list. Dan, why don't you talk to us a little bit about how you anticipate the SEC and FINRA to enforce with respect to elderly and compromised investors?
Sure. So I think the preface to this is the data and statistics on financial exploitation of the elderly and the disabled are really shocking when you look at them. And when you see some of this data, you understand why regulators and plaintiffs' attorneys are so honed in on this. So for example, the most age 65 or older have been affected by elder abuse. Seniors lose an estimated $2.9 billion annually from fraud or financial abuse. And that's just based on reported cases. And the data reflects that only 1 in 44 cases of this type of financial abuse is actually reported. SARS reports are a good way to keep tabs on this. And in 2013, the SARS reports were updated to include a specific box to check if the filer suspected that the case involved elder financial exploitation. SARS filings have exploded, and in 2017 alone, financial institutions reported a total of $1.7 billion in suspicious activities targeting the elderly. So I think the next topic, let's talk about the 2 basic FINRA rules on point here. And the first one is FINRA Rule 4512. This rule requires firms to make reasonable efforts to obtain the name and contact information for a trusted contact person when a retail customer opens an account and when account information is updated. Now, customers are not required to provide this information. The supplementary materials to this rule provide that associated persons are authorized to contact a trusted person and disclose information about the customer if they suspect financial exploitation, but this is not mandatory. And we're going to talk about this later, but the distinction between mandatory and discretionary reporting is very important because there are a lot of state laws that do require mandatory reporting. So the second FINRA rule is Rule 2165, entitled Financial Exploitation of Specified Adults. This rule covers customers who are 65 and older and customers who are 18 and older and who the broker-dealer reasonably believes has a mental or a physical impairment. Now, this rule permits broker-dealers to place a temporary hold on disbursements of funds or securities from the accounts of certain customers if the broker-dealer reasonably believes that financial exploitation has occurred or will occur. And again, this is discretionary. It's not required, but this rule allows broker-dealers to place a temporary hold. Firms can do it. Firms need to notify the trusted contact within 2 business days unless the firm thinks the trusted contact is the one involved in the financial exploitation. Broker-dealers are allowed to place an initial hold of up to 15 days on customer funds, but can extend the hold for another 10 days. And there's an interesting distinction here. This rule does not allow broker-dealers to place a temporary hold on securities transactions. Instead, it only allows a temporary hold on the disbursements of cash and securities. Now, as I mentioned, there are a lot of state-level elder abuse statutes that are different from the Finra rules. So that's something that broker-dealers and associated persons need to be aware of. The big distinction here is a lot of these state laws are much more aggressive and they require mandatory reporting. For example, Ohio has an Elder Justice Act that requires banks, financial advisors, and other people in the financial services industry to alert Adult Protective Services if they suspect elder financial abuse. These folks are considered mandatory reporters, and they're immediately required to report suspected exploitation to Adult Protective Services. And I believe that in January 2020, California also passed a similar law requiring broker-dealers and investment advisors to report financial abuse and exploitation. The last thing I want to cover here are a couple different potential issues for broker-dealers to watch out for and some kind of practical tips and pointers we have. So the first area firms are going to see this is the sort of traditional example of elder abuse being perpetrated by a family member or some sort of third party. Here, firms just need to carefully monitor accounts of senior investors. And this really goes back to kind of FINRA know your customer rules. It's tricky because firms and associated persons are not trained as social workers, but they are required to periodically meet with their customers, stay in contact with them, and really know their customers. So it's very important, not only in the context of defending regulatory inquiries, but also potential litigation, just to know your customer, document the meetings, and be on the lookout for any obvious red flags of elder exploitation. And the regulators are strongly encouraging firms to have training programs for associated persons and their supervisors on this. And the NASAA, for example, has something called the Senior Safe Training Program, where broker-dealers and investment advisors can contact securities regulators in their jurisdiction and request a presentation on training specific to that state or jurisdiction when it comes to elder abuse. Now, the types of claims that our clients are most likely to see in the normal course of business are essentially suitability claims from PIABA attorneys that are dressed up as elder abuse claims. And we're seeing more and more of this. Anytime you have a claimant that's 65 or older, number one, PIABA attorneys are filing these as expedited arbitration proceedings, trying to push them through in 6 months. And number two, in addition to suitability claims, they are very often tacking on elder abuse claims. And these are potentially scary. It's not clear they're always applicable, but they're potentially scary because most of these have pretty significant special statutory damages. Jim and I are based out of Illinois, so I'll talk about the Illinois elder abuse statute briefly. We've seen this in a lot of statement of claims. The Illinois statute provides for treble damages as well as reasonable attorney's fees and costs. Now, when you really drill down on the language, the statute requires that the person, quote unquote, by deception or intimidation, obtain control over the property of an elderly person, or quote unquote, illegally use the assets or resources of an elderly person. So in these sort of cases, it's always our position, look, these were authorized investments. To the extent you're taking issue with suitability, that's clearly outside the scope of these statutes. But it's never clear how a FINRA panel is going to rule on that. And when you have a big, juicy statutory claim with special damages, that can potentially raise the price of poker. Now, in terms of kind of practical pointers, we are not recommending that firms create special WSP provisions for investors over 65, because our experience has been that often those are the most wealthy and sophisticated customers there are. I mean, Warren Buffett's 90. So I think you can use that as an example. You can't really have a one-size-fits-all rule. So this really goes back to knowing your customer. We've seen elder abuse claims typically in annuity switching cases with elderly folks and alternative investments where there's an over-concentration. So those are two specific issues to be aware of. The two final points, you know, it's unfortunate, but firms actually do end up getting sued by the very elderly customers that they're trying to protect. There was a famous case where Fidelity was sued for over $1 million for freezing the accounts of an elderly investor who Fidelity thought was suffering from diminished mental capacity and was being taken advantage of by a neighbor. So it's a very tricky line to draw in terms of protecting these folks, but also respecting their rights and autonomy. And again, this goes back to knowing your customer and just throughout the process, documenting your concerns and what you're doing to address it. That sort of documentation is extremely valuable when it comes to defending lawsuits or regulatory matters. And then finally, you know, be cognizant of the Finra rules, but be cognizant also that when you have elderly customers in different states, a lot of these states are getting more and more aggressive with their own elder abuse statutes. And a lot of them may require more than is required by Finra rules. And the mandatory versus discretionary reporting is a pretty clear example of that.
Thank you, Dan. That was a wonderful presentation. And I guess the question too is like, how far do broker-dealers need to go? I'm aware of a broker-dealer that has actually set up internally like a task force. So if they suspect that one of their clients is a victim of elder abuse, they have taken it upon themselves to, you know, protect that client as much as they can. They will put a freeze on the accounts. They will refer the case over to the FBI. And they've actually been very successful in thwarting really serious elder abuse situations. Now, I think that that's probably an extreme example, but this is a broker-dealer that has decided that this is what they want to do to protect this sector of their clientele. And they have really protected a number of these clients who have been subject to elder abuse. But, you know, elder abuse is certainly one big topic. Another is private security transactions and outside business activities. So let's spend a few minutes just talking about that as well, unless somebody else has a comment about elder abuse before we move on.
Just a quick point on something Dan said. I'm just curious whether your office, Dan, and Gary, whether your office as well is challenging any of these claimants attorneys, you know, immediate request for an expedited hearing. You know, from what I see, you know, once they put in that request, Finra just pretty much summarily just accepts it. But what we do is we at least go to the rep, say, hey, do you know of any impairment here? I mean, why is this expedited besides they're 65 years old? And if we don't believe that there's anything necessarily mentally wrong or physically wrong or really necessitating an expedited hearing, we'll challenge it and kind of put it back on claimants counsel. Like, why do we need this expedited? Only to kind of level the playing field a little bit. It's like, simply because you're 65 doesn't mean you're incompetent, that you're unable to make investment decisions. I just think, you know, so often they go swinging with this to create this sympathy factor. And I just think you're kind of, you know, already on your heels if you're at an expedited hearing with a senior, and it just kind of, you know, creates this impression that may not be reality.
Yeah, I think we've challenged that. I mean, you look at the panels compositions, the majority of them are over 65 too. So if you've got somebody that's 65, 66 years old, you know, and everybody's got a crowded schedule, you can just we would just kind of turn the panel. It's like, listen, there's really no reason for this unless there's some evidence of some kind of really kind of incapacity. You know, that we found panels pretty receptive to that, especially now with the current situation. Nobody can get a hearing scheduled at all.
Well, I think you immediately call on the credibility of counsel at the very least, right? If they've kind of created this impression of some elderly individual, on their deathbed, and it's simply not the case. The panel sitting there saying, all right, what type of claim are we talking about? Is this just something that's really drummed up by claimants counsel?
Yeah, the argument I've made to panels is this: my mother's 70 years old. If I called her elderly, she might slap me.
Good point.
Well, let's move on and talk a little bit about private security transactions and OBAs. Who'd like to start that conversation?
Well, I'll go ahead and take a crack at it, Lydia. This is addressed in detail in the most recent Finra report on pages 11 through 13. But before I get into the Finra findings, I think I'll start again by just summarizing the two relevant Finra rules. So Finra Rule 3270 involves outside business activities. And the gist of that is that firms are required to have associated persons provide written notice and get approval for any outside business activities they want to be involved with. The supplementary materials to this rule provide a little more sense for what FINRA is looking for here. They want firms to consider whether the proposed OBA activity will interfere with the registered rep's responsibilities to the member or the member's customer, or be viewed by the customers or the public as part of the member's business. And if an OBA activity is approved, firms not only need to keep a record of that, but they also need to consider whether specific conditions or limitations need to be applied to that OBA activity. Now, FINRA Rule 3280 involves private securities transactions, and this is a little bit more involved. So Part B of the rule requires prior written notice. And then Part C addresses transactions for compensation. So the firm needs to specifically approve any PST where the rep's going to be getting compensation, direct or indirect. And then the real kicker is if the member approves the person's participation, and I'm quoting now, the transaction shall be recorded on the books and records of the member, and the member shall supervise the person's participation in the transaction as if the transaction were executed on behalf of the member. Now, PSTs that are not for compensation, the firm still needs to approve or disapprove them, and they also need to place any applicable conditions or limitations on it. But the main focus here is on PSTs for compensation, and the definitions to this FINRA rule note that compensation refers to direct or indirect compensation. And this is something that FINRA found in its exam findings that firms were not getting right. FINRA found that firms were exclusively focusing on whether reps got upfront compensation. And an example would be a rep that was raising money for a firm where he was a shareholder or sat on the board. He may not be getting a finder's fee based off raising money, but he's going to be getting indirectly compensated by virtue of his position with the company. So to kind of tie this together and summarize these two rules, firms need to approve OBAs and keep updated records of that OBA activity, but they're not required to supervise the minutia of the OBA activity. But the reverse is true for PSTs, especially PSTs for compensation. The firm has to supervise and record those transactions as if they were going through the firm. So,
Gary, I'm going to direct this question over to you. Have you encountered any situation where an OBA has been approved and there were issues with the registered rep's description of that OBA activity?
Yes, in fact, we've had a series of cases that flowed from an OBA that was approved by the firm, represented by the rep to be the sale of collectibles and jewelry. That was it. The firm inquired, are these items being offered as investment products? And the answer was no, they're not. lo and behold, they were. And that OBA quickly became a selling away case, private securities transaction case,
Yeah.
multiple persons in discovery. We were able to find, through email reviews, emails from the rep offering $200,000-$300,000 diamond rings, talking about appreciation of the rings, making it part of an alternative investment strategy to complement their investment portfolio. And so it's a difficult situation. The firm really has to drill down, and if the rep's going to lie about it, they have to be very vigilant in their office inspections and their reviews of their emails to try to find things about the actual disclosed OBAs if there's a chance for misinterpretation or in this particular case, what is a collectible and what is jewelry. So,
Well,
Right.
you raised a
And
really
I think one of the big issues there is really kind of education, because I think in a lot of instances, a lot of cases we've handled it, there's some issue whether the rep believed it was even a private securities transaction. The manner in which he was selling it, selling this for the appreciable value of it, didn't even understand that was a private securities transaction. That's something a broker dealer can do can ensure that their reps understand what a private security transaction is.
We had a letter from an attorney that said it wasn't a security, Brian. I mean, what was he supposed to do?
Right, exactly. But yeah, at a cocktail party, an attorney told me what a security.
But you know what, you raised a really good point, because I'm aware of a claim that one of my clients was involved in. And the registered rep asked permission to engage in this outside business activity. He was told no. He was told no in writing. He was told no verbally. His office was inspected. There were office inspections, knowing that maybe there's a possibility, but let's go out there, let's do an inspection. And a claim comes in outside RIA, non-client of the broker dealer, and the broker dealer's on the hook selling away. And so my question is, what does a broker dealer do to protect itself against these outside business activities where the broker dealer has specifically denied that registered rep an opportunity to engage in that activity? I mean, that's their challenge.
Monitor the document. I think, you just got to stay on it. I mean, yeah, you can only tell them no so many times, but document the no's. So often, remarkably, it still remains, undocumented that we told them no, or he or she knows. So it just paper the file with that. And if they go out and, disobey, then, I mean, you just throw them under the bus, obviously, as far as you can, under that bus, and, do your best to defend it. But the problem we see is when, it's those little red flags even that pop up in documentation that you didn't follow up on, you didn't monitor, that make, they make mountains out of molehills. I'm referring, of course, to the plaintiffs.
Yeah, and the review of electronic communications, I know, is getting more difficult all the time, but you have to make sure that you got a proper lexicon built. That might afford you some protection. Hey, listen, here's what we were looking for, and nothing came through our filter. So
Mhm.
And the lexicon one is good, Byron. We had a case where a OBA was disclosed, right? And they said no sales, being generated, but the firm added that company name to a search every once in a while to that rep, and ping, they found, they got a lot of hits on that. So sometimes you got to do, it's all monitoring. You just can't just stop at the OBA document. You got to dig, you got to document. And if you show you digged and and you didn't find anything, then, it's reasonable at the end of the day.
We've used ACQs, the annual compliance questionnaires, to show that the reps have said that there were no OBAs involved. But the problem is, as Chad and Gary has alluded to, and Brian has alluded to, is sometimes the email traffic doesn't support the the no and the ACQ. So you have to be careful of how you manage that.
And a big emphasis in the Finra report, they don't want firms just taking the rep's word for this. And I'll just talk real briefly about some of the things that Finra is proactively looking for firms to do in terms of undisclosed OBAs and PSTs. You know, Finra obviously wants training and adequate written procedures, but they put a lot of focus on doing an independent investigation at the time of the initial disclosure and periodically thereafter, including reviews of social media, emails. Emails is a huge one. Interviews with the reps, documentation of the supporting activity, red flags to be aware of, significant changes in a rep's lifestyle, performance or production levels. Finra is looking for firms to do background checks, look at customer complaints, look at financial records. And one other thing that was noted in the Finra report is that Finra was concerned that a lot of reps were receiving PPP loans for undisclosed OBAs and that firms were not picking up on that. So Finra specifically said they want firms looking at publicly available PPP loan information to make sure their reps aren't engaging in undisclosed OBA activity. And practically, I mean, the big things you can do, background investigations, internet search, email's huge, and reps will often use personal emails or scan things in and try to find creative ways around that. But you've got to be really diligent with keyword searches. And then we've seen this in a couple cases. Reps with high-risk OBA activities come over and the firm waits until the end of the third year to do a branch exam. If you got a high-risk rep coming over with an OBA, do a branch exam in the first year. That way you got something to show to the panel or the regulators, hey, we were really being proactive here.
We're going to switch gears a little bit. Over the past year with COVID, there have been challenges in communicating with the clients. So registered reps and advisors have probably employed different means of communicating. I wouldn't be surprised if a number of them are texting, Zooming, certainly, and everybody emails. But are broker-dealers and RIAs set up to capture all the different communication means that are being employed by the registered reps and advisors? And, you know, what are some of the issues and challenges that you see and that FINRA and the SEC is focusing on? Gary, you wanna comment on that?
Sure. There are third-party services that can capture text messages. I don't know the cost of that service, but they're certainly there. And I know they're there because today Brian and I spent a bunch of time on the phone with an FBI agent and a chief compliance officer on an elder abuse case that the San Diego FBI office is handling, where the registered rep and investment advisory agent had basically absconded with funds from the client's account by writing checks on the client's elderly client's account. And the firm had different text, was able to find text messages after the fact, unfortunately, that would have indicated that there were questions raised about disbursements out of this person's account. So yes, it's just like the emails. It's good and bad. You can capture and you should capture, and I think you're required to capture them if you allow your reps and agents to use those types of communications. I think the better thing is to say no and not allow it. It's hard enough to review emails. Once you start getting into text messages and Snapchat and everything else that's out there, you're opening up a can of worms.
But we know that there are going to be some reps and advisors that even if you say that you can't communicate by text, they're going to. How does a broker dealer overcome that problem? Because they're going to get dragged into the litigation. You know, they always do.
And I guess you could look at their cell phone bills as part of your office inspections and see if they make them have detailed cell phone bills and see how many text messages they send. At that point, I mean, there are ways, I guess, to kind of figure out if that's happening.
Right.
I mean, I think more and more firms are certainly using vendors. I mean, they're not equipped to monitor, emails, let alone text, but the vendors are getting a little bit more sophisticated. I'm still not a big fan of using text. I just think we already get somewhat lazy and loose with our tongue in an email, let alone what reps are putting in text messages. So, but I know firms at the same time want to be relevant and so forth. I just don't know how you can monitor an emoji and what, and how, whether that's sufficient documentation or not. But this is one other area, though, that I go back to the priorities letter, Lillian, where there are several pages of exam findings and effective practices that are itemized by FINRA specific to communications with the public. And, those effective practices, like I mentioned earlier, could be, one other way of saying it is their best practices. And, they deal with all different kinds of categories of communications. So I would certainly want to be up to par with, each one of those topics. And if you're not, talk to these vendors and whatnot to get up to par.
From a firm's perspective, we've been asking the firms to, well, a lot of firms have included in their annual compliance questionnaires that they're not using text. On exams, we've asked them to look at the reps' cell phones to see if there's any text in the cell phones. And we've also been telling them that in their annual compliance meetings that they need to have a discussion about text messaging and communications to the public. So that's our 3-phase plan to try to limit that. We do know that it will spill out. I mean, it's obvious that it will spill out, but at least we've got some documented proof that the firm has utilized as many resources as they can to stop the texting from happening.
Obviously, though, it's a customer service issue, right? You're going to have customers that's the only way they want to communicate. And I can't imagine that that's going to grow. I think we were preparing for this. I made the comment that's really the only way I talk to my kids anymore is by text. That's how they
Right. Yeah, my parents are texting now, which is kind
of. My mom's the same way.
Yeah. So let's talk a little bit about social media, websites, the supervision by the broker dealers of the social media sites and the websites for the reps and advisors. Another big area.
Well, certainly if you allow them to have a website, some do, I think it's on you then to monitor that. And, every once in a while, comb that website to see what they're publishing and also look at, the hyperlinks to where they're sending people as well. Just to, again, just to monitor because, I don't know why a rep necessarily needs to have their own website, but particularly those that are RIAs and the hybrids, they often do. So that's certainly going to be, something to look forward to, whether a firm has an obligation to supervise that RIA and on top of that, their website, that's probably a different discussion. But if you're going to allow it, yeah, you have to monitor it. Social media, I mean, if we're talking now communications on Facebook and Instagram or whatnot, I would hope that most firms are not permitting those. I think text messaging is enough. I don't, but we see some communications happening even through the professional, LinkedIn, which, tends to be a little bit more professional and someone could, post a nice piece, an article, and then all of a sudden it kind of goes on and on. But yeah, certainly challenging. I mean, it's challenging just to stay relevant and be in front of it at the same time.
Have any of you
And
been involved in litigation where social media has been an issue?
Can I just go back? Can I just go back and follow up on Chad on the website? I'm sorry. On the website, we have asked people to make sure that they have record retention of changes to the website and store that as well. So that gives us some documented proof as to what's on the website and what changes have been made. So we have WSPs that talk about that, and we have our exam people or my clients' exam people go in and check on that when they do their inspection of the offices. So sorry.
No. So is it more of a regulatory issue as opposed to a litigation issue? Violations with respect to websites and social media?
I think it is a regulatory issue, but as we can see from like the elder abuse conversations we have, a lot of these things will lead to litigation and practices that the plaintiff's counsel can grab onto as bad practice of the firm. So, you know, I think that that's important as to what's going on.
I mean, just on the topic, go
Go
ahead.
ahead.
Now, the
We also-
topic of social media, I think, you know, one thing that, you know, firms can do, you know, if you start to send some red flags, you know, certainly social media is a host of information and, you know, to monitor, to look into what that rep's possibly doing. I know, you know, just internally here, when we interview a, you know, a candidate, you know, we're going to go out and look at their social media. I mean, we should be doing the same thing for these reps, particularly ones that we have, you know, that we have potential, you know, concerns about, because, you know, go check out what they're posting out there and how they're presenting themselves, because, you know, there's a lot out there.
Yeah,
In
one of the
fact,
things,
one of the FINRA priority hints was to review the rep's social media for purposes of outside business activities.
Right.
That was one of the methods that FINRA thought would disclose unreported outside business activities.
And a lot of, I don't know about your clients, but a lot of my clients do look at social media when they're doing the onboarding process of the reps too. So they'll look at the reps onboarding social media when they're doing their onboarding process.
Well, onboarding was a big issue, I remember, from last year, you know, hiring rogue reps, or the crackdown, I should say, of rogue reps. What have you found with respect to this year's priority list in how the SEC and or FINRA has addressed that issue? Was it even addressed this year? Because I know that it was a big deal in the past.
Yeah, I didn't see any highlight of, you know, onboarding rogue reps. I mean, it's certainly an ongoing issue, but it wasn't a priority per se that I saw.
Well, another priority I know that we've talked about, variable annuities. It seems like variable annuities just don't go away. So why don't we spend a few minutes talking about the vulnerabilities of selling variable annuities and the SEC and FINRA's focus on that. Brian?
well, you know, I think that, you know, from a claims perspective, I don't think PIABA has ever seen a variable annuity suitable for any client. You know, and I think
Sounds like Ken Fisher.
you know, the focus, I think, you know, it's, you know, on these variable annuity switches. You know, there could be a valid rationale for switching a variable annuity through an exchange, but those are going to be questioned because of the commissions, upfront commissions on them. Especially if you've got a rep that's got, you know, 80-90% of his business in variable annuities. I think that the main thing you can do is you're going to have, and it's going to have to be reviewed by compliance, documenting the rationale for that switch. Right? It's got to be detailed. You know, there's got to be a very detailed rationale. If you're going to, you know, you got a better opportunity for this particular rider. This rider will accomplish this for the client's investment objectives. I think the whole key on those switches is documentation. And we had a case in which an older guy in Louisiana, that's basically all the business he was doing, was switching variable annuities, and it was not pretty, you know, when FINRA came in. So I mean, it's a big deal. Like Glenn said, it's not going away. And from a compliance standpoint, you just have to make sure that those, you know, the rationale for the variable annuities is very well documented.
I think it starts with a good switch board. You know, I've seen firms that have good switch templates that are required for every exchange. And it, you know, it doesn't just require the rep to document, but has the client sign the document as well, showing what they're giving up, the new bells and whistles that they want. You know, everything the rep's telling you as to why they're doing the switch should be there, in terms of, why are we making this switch? Are there surrender charges? And, let's compare A to B and find out, if this makes sense. And then also having a supervisor review. If they can't fill out that form, perhaps, we shouldn't be pursuing that switch.
And these switches really tie into Reg BI as well. I mean, the best interests of the client, you've got to establish that there's no conflict of interest, and hence the very detailed documentation. How about some buyout offers or, other things that are related to the sales of variable annuities? Anything else that we want to address at this point?
Well, it also extends to riders as well. When the clients buy different riders, I had a SEC investigation where we looked at about 50 riders for all the clients. We were able to show that we were able to do all that, but we had to justify the rationale and the money actually with respect to the riders and whether it was worth it or not for the clients. So as Chad was saying, documentation is everything. Chad and Brian were saying documentation is everything. And we were lucky we had all the documentation, but we had to do a lot of math.
I mean, again, you see in the priority letter under effective practices, FINRA is saying they want to see detailed written rationales for exchanges. I mean, if you're going to go forward with an exchange, I'd want to see a detailed written rationale. Period.
Yeah, as far as the FINRA priorities, if you're going to read any of them, as far as detail, they have 4 pages of effective practices spelled out for variable annuities. And they're basically saying, look, this is what we expect to see. And if you don't have it on a switch, there's going to be an issue. I mean, bottom line on it.
I mean, that's what you were all commenting on earlier. Read the FINRA priority letter and make sure that you can accomplish and satisfy all the different points that FINRA has made. So we're just going to, finish up with talking a little bit about branch office audits, suits by customers versus non-customers, and how about some red flags and investigation issues? Chad?
Red flags, what are those? Well, in terms of like internal investigations, yeah, I mean,
Branch audits.
yeah, certainly, oftentimes I think, well, nowadays with COVID, it'll be, how these firms are conducting their investigations has certainly changed. Over the last year, it's been remote. Talking to clients, I know a lot of firms can't wait to get back out there in the field, but they're not requiring that to happen yet. So I think they've been somewhat limited in terms of at least being able to do an on-site, visual of the rep's office and so forth.
Mm-hmm.
So I know that's been a challenge in and of itself, but I think the biggest takeaway that I have is when there is an audit and you have that checklist, and you can see something that was talked about but just not followed up on. Again, it's like if you see a red flag of some sort, you not only have to document, you got to show what you did with that red flag. Go ahead.
So do you think that the SEC or FINRA has offered a little leniency with respect to branch audits because of what was going on over this past year? Because, broker dealers are doing virtual audits. Are they giving them a break at all?
We'll see.
I mean, the big issue was really whether they can do remote audits, and the challenge for the examiners to do remote audits, whether it's through Zoom or through otherwise. There's a big question as to, whether you give them a document request before you go into the exam audit, because now they have everything and you can't see whether they really have everything or not. So
surprise audit by Zoom is kind of tough.
Yeah.
Yes, definitely. So, and the documentation related to that is also crazy.
Yeah.
So we have had quite a few clients that have challenges as to what to do. We've helped them develop remote exam questionnaires for the short duration that we still have remote examinations. And we think that that's actually not a bad thing, because that gives them a lot more opportunities to do more exams on a shortened basis.
Well, as a closing, I would like each one of you to just give one final tip to our audience with respect to the SEC and the FINRA priorities? Just one tip that you'd like to share, Gary?
Write it down. If it's not written, it didn't happen.
Jim?
I like that. Documentation is what I always tell my clients.
Dan?
Know your customer and document the interactions.
Chad?
Specific to these priority letters, I would have some documentation of, some internal review with each department on each of these subjects that you actually went through this and be able to show that.
Very good. And Brian?
If you want to know what's coming down the pipe, just read them.
And with that, I want to thank everybody for joining us today. Please feel free to follow up with any of us if you have any questions. And really, it was our honor to spend the hour with you. Thank you very much.
Thanks, Lillian.
Thank you.
Thank you all.
Thanks, everybody.
Thank you.